this panel is really about legislating contract clauses and the different ways that we do that. So this could be enacting laws, regulations that dictate specific terms, conditions, clauses that must be included in government contracts, or maybe can't be included in government contracts. And it promotes certain policy goals, right? Ensures consistency and protects the interests of the government and the public. So that's kind of the context for our conversation. So let's talk a little bit about the Christian doctrine, which, contrary to some belief, has nothing to do with religion. Just happens to be the name of the case. So the Christian doctrine is a case from 1963, and it was a mandatory statute or regulation that expresses a significant or deeply ingrained strand of public procurement policy shall be read into a federal contract by operation of law, even if the clause is not in the contract. That's the basic premise of the Christian doctrine. And the court's rationale was that procurement policy set by higher authority cannot be avoided or evaded just by, let's say, forgetting to put it in the contract or something of that nature. So as we got talking about this, the Christian doctrine itself doesn't apply to states, but some states do have similar legislation, and we wanted to really talk today about the different ways that this does or doesn't apply in our states, and just kind of really talk through some stories, right, from each of our states and how legislating contract clauses can impact how we operate. So with that, there's some additional things. I'm going to turn it over to Angela and Christine to talk about your story in California.
Great. Do you want to get?
Yep.
I'll get started,
Okay.
and then I'll toss it to you. I think you're under high roads. So California has a long history of legislating contract clauses. I think it's been going on, so far back. And, it's usually to the point that Valerie made, it's about sort of prudent business practices. But there's a lot of public policy reasons, certainly in California, for legislating those clauses. The most recent one, it's actually not legislative, but it was an executive order by our governor regarding Russian-Ukraine-related sanctions. And so that really required contractors to comply with economic sanctions if the contract was over a certain dollar value, and they had to report their compliance and disengage with Russian entities. This is a huge lift on the state of California, the notification process, coming up with the templates, advising all the departments. The Department of General Services, we don't do all the contracting, obviously. Each of the departments within California have that authority. And this was one example where we had to sort of take it and run with it very quickly and implement this statewide for, I don't know what the number of contracts was that it impacted.
Thousands.
Yeah. But that's one more recent example. I don't know, Angela, if you want to add.
Yeah, so that was a recent one. The High Roads job language is actually a statute that was enacted starting January 2023. And so we had our legislators reach out to us. Actually during COVID is where this High Roads jobs term sort of became coined. And it was around the economic recovery of entities in the state, employees that had lost their jobs, companies that had perhaps gone out of business because of the impact of COVID on the state and the shutdown of our state. And so the legislature came to us actually during our emergency operations and wanted us to include some very specific language in our emergency contracts, of all things, in our emergency contracts around job protection for workers in the state of California. And I mean not state workers, but vendors, employees. And so we were under immense pressure, and at the time we said, okay, we will pilot this, if you will. And then lo and behold, a statute came out in the state of California. And there was a lot of debate around this statute because it's fairly controversial, and some parts of it are laws that we already have in place in the state of California. And so some of it is like, okay, why are we enacting a statute to apply laws that already exist just across, our laws in general as it relates to contracts. And so it was very narrowly tailored down to a specific type of contract for now. There were several. This high roads jobs ended up in about probably 4 pieces of legislation, and a lot of that legislation was actually around sustainability. So starting, of course, for California, so our sustainability efforts are massive, and there's always a plethora of statutes or potential statutes that come out every year through our legislature around sustainability. And so it really started in the sustainability space. And only one of those laws actually got passed in this last session, and it applies to our zero-emission vehicle transit contracts. And so in California, we have a couple of contracts that we do, and interestingly, they are not for the state of California. We put them in place actually for our local entities, but we do have some bus contracts, zero-emission bus contracts, and zero-emission school bus contracts. And then, of course, our Department of Transportation has some rail contracts. And so this law was put into place for jobs, for contracts over 10 million. So it was kind of negotiated down, and that's where we ended up. And it's significant because it has a lot of pieces around, again, existing statutes, but it goes a little bit more in depth. A couple of the areas that it puts out there is things like fair wages, and one of the pieces of that is that employers should be offering healthcare benefits, and it's up to $2.50 per hour. So we don't generally have a statute in the state with respect to our contractors around, mandatory healthcare benefits. It has things like no misclassification of workers, and that is related to another statute that we have in the state of California where they don't want employees to be misclassified as independent contractors, so you waive all of the employment requirements. Paid sick leave, workplace safety and health, which is again another one that's kind of like, okay, we have lots of statutes on workplace safety and health that they're, contractors are required to comply with, but it's in there. ADA compliance, again, already a law. And then one around labor peace agreements, which is basically, no striking on these particular contracts, and that the contractors cannot bar their employees from unionizing or organizing or, being a part of that. And so for now, again, it relates to zero-emission transit contracts and then EV equipment contracts. And those were really sort of directed at the Central Procurement Office because we are the ones that issue those particular contracts. And so I don't believe that it will be the last time we will see this piece of legislation, and I think they will easily find out that it applies to maybe 1 or 2 contracts in the state of California that predominantly the state of California is not actually purchasing from, it's the locals. So I think the impact will not be felt for quite some time. The other piece I forgot to add in is that there are some compliance pieces that are associated with it. So contractors have to annually submit a report to the state on how they've complied with these particular provisions in the contract. If they don't, they're fined $10,000, which is not significant in a $10 million contract, but $10,000 for the missing report. They get a cure process, and we do have the potential of terminating the contract if they never submit this report annually on how well they're doing. So it's again, I bring it up because California has a lot of laws in place, contracting laws around these topics, but it sort of synthesizes them all in one place, and this isn't the last that we'll see, and it is focused on transportation, but I can see it expanding to a lot of other areas in the state. So.
And I think the theme there is like many of these legislative required contract clauses, a lot of them already exist in other provisions of the code. They're the cost of doing business in the state of California, but they sort of take that and then impute that into this required contract clause. So the lawyers sort of get grumpy because they're like, well, this is already in the law. Why do we need a contract clause that says you have to do this, reiterates it, and sometimes in a manner that's inconsistent. It's not always a perfect match. I know we have that with one of our loss leader provisions. It doesn't actually match the Business and Professions Code, what's required under the Public Contract Code. So I think it's just sort of a little bit of a legal issue for the lawyers when you have to look what's the underlying requirement to do business and then what's required in the contract. So this one is a table from California's State Contracting Manual. This specific manual is for non-IT service contracts in California. And so we put helpfully together a handy-dandy chart of every single clause that's required and whether it's required by statute or whether it's required by policy. And I think, this is a helpful way for all of our departments to understand where these requirements are coming from. And so everybody sort of references this. I think the next one is maybe one more picture. There's like 4 pages of this. So this is on DGS's website, the Department of General Services website, and I'm happy to send out the link if anybody's interested. But you can see that column on the far right lists out, for example, insurance requirements as state policy. And so going back to Valerie's point in the beginning about the Christian doctrine, and I started thinking about that as it applies in California, we don't have a California-specific provision of that, but we do have a section of the Public Contract Code that says every contract entered into in violation of the Public Contract Code is void unless the violation is technical or non-substantive. So arguably, if your contract did not have a statutorily required term, we could say technically could be voided. All contracts in the state of California also require the contractor to comply with state law. So presumably, even if you left a clause out, if it was in one of those rows that was required by state law, you'd still be required to comply. But in chatting with some folks from my office, there was sort of this one little black hole there, which is, well, what about those that are only required by policy? And so if for some reason you left out that one required by policy, what would that mean? Would you still be required to comply? And that's the one where we thought there might be a little bit of a gray area. This isn't being recorded, right? I don't need to teach any. Oh, it is. Okay, well, we're not teaching any contractors today. But I think that's one area where we think that there could be a gap, essentially, by maybe not having a provision, a equal provision in California state law.
Great. Thanks. All right, so let's turn to Georgia. McCall.
So Georgia law has a similar provision. I'd start off with that voids contracts that are contrary to the rules and regulations. This part is our State Purchasing Act. So it then goes on to talk about how individuals who enter into contracts contrary are personally responsible, which I think you had mentioned in Idaho is the case. That aspect in Georgia, unlike California, we have just a couple of clauses. So one of them is drug-free workplace. How many of y'all have a drug-free workplace clause? Yeah, it's a pretty common thing. That's one of them. But a lot of our policies and the things that you were talking about, like I think last year the Ukraine aspect came into legislation. Ours come in at the front part of competitive bidding, so that suppliers have to certify that, so that's part of your bid as opposed to, and I know the bid's really technically incorporated, but it goes towards that supplier responsibility determination and who we can contract with. So E-Verify is another one that comes up. Suppliers are required to, in Georgia, to provide an affidavit that they use E-Verify along with information such as their E-Verify number, when they applied for E-Verify, and then they have to pass that requirement down to their subcontractors and their subcontractors. Lots of affidavits, and they have to do it for each contract. So unfortunately, that's not a contract clause, but it's an ancillary aspect in Georgia. So usually what we try to go to is substantial compliance. But when I was looking at the substantial compliance provision, it says that substantial compliance with any statutory requirement, especially on the part of public officers, shall be deemed to be held sufficient, and no proceeding shall be declared void for one of such compliance, unless expressly so provided by law. So we did have that expressly provided by law, so I don't know that substantial compliance would get us out of that situation if somebody forgot to put in drug-free workplace. I've been with DOS for 10 years and in procurement for another 10. The issue hasn't come up. So I guess we're fortunate in that aspect. So this is the next, I don't know if you want to talk about Idaho too.
Yeah, I can do that. So we've got so we've got something very much like what Georgia has here, so I'll leave that for a moment. But we do have two specific requirements as far as certifications that we have to have in our contracts. So they're both written in very similar fashion. One requires that the contractor certify in writing that there's a written certification in the contract that they do not and will not for the life of the contract boycott Israel. And the other is a written certification that they are not owned or operated by the government of China. So the way that we've, kind of worked that in is to just put it into our standard terms and conditions, and then when they submit their bid, they agree to those standard terms and conditions, and that way that, we consider that to be the written certification, so that it's in there. But, opposite of the Christian doctrine, essentially, the way the statute is written, if we fail to have that written certification in a contract, there's sort of a cure period. If we realize that we have forgotten to put it in there, we have a period of time that we can essentially amend the contract to get that written certification in. But if we don't do that, then the contract is void. And so, and that's why, we've built it into our standard terms and conditions so that we hopefully don't have that situation. And it allows, essentially, if the contract is already in place, so the one related to Israel went into effect, I want to say 3 or 4 years ago. The one related to ownership by the government of China was just this last session, so almost a year ago. But it basically allows us to, if the contract is already, it applies to new contracts entered into after the date that the legislation goes into effect, but we also can't renew a contract or amend a contract unless we add it in. So that's for those pre-existing contracts, we still have to get it in, which it just makes for extra work for my contract admin team, that they've got to make sure that they're checking with every contract renewal. Okay, when did this contract go into effect? Does it have it in there? Does it not? So those are the two that are specifically required terms in the contract. And frankly, I think we're going to continue to see that happen. I think that there's sort of a template out there now for the legislature to use as a way to sort of build that policy into our contracts. What's interesting is there's no real obligation for us to do anything other than have that written certification. So the question becomes, well, what if they're not complying with that written certification? Are we really going to do anything about it? I don't know. But I think it's sort of an interesting way to sort of get that politics piece into the process. So we'll see. I think we'll see more. I saw draft legislation last year, and I know there's several of you here from Texas, has some legislation related to the firearms industry. I saw that float around. I saw some related to agricultural industries float around last year. So I think we'll continue to see, in Idaho anyway, similar legislation of those types of policy terms. And then similar to what you can see on the screen in what Georgia has, so just for a tiny bit of context, our administrative rules in Idaho have to be approved by the legislature, so they are essentially have the full force and effect of statute. So ours are in rule, but essentially similar effect. We've got a list of terms that if they are included in a contract, the term is void. And that includes things like, waiving the various indemnification, waiving the, sovereign immunity of the state, things like that. So we've got a list of those that are, now, hasn't been tested, knock on wood. If I'm here next year saying how I jinxed myself, you'll know why. But that's sort of the opposite, right? That we've got this, if you do include, right, it's the other opposite of the Christian doctrine. If you do include this, we're going to read the contract essentially to not include it because it's against public policy. So McCall, let me turn it back to you to talk about kind of Georgia's version of that.
So I went to Law Institute, must have been probably first, second Law Institute that I attended. And Colorado had just revised their procurement statute, and they came to present on it. And I thought, this is the most brilliant idea. And it was Challen Weiner, and he talked about they had codified all the things that we always have to tell suppliers and produce fragments of AG opinions and court cases, and they codified all those aspects. And I thought, that is just genius. So that's what I try to do at Law Institute, is I try to find something that somebody else is doing really well and take it back and tell people where I got it from, of course, but try to make it our own. No need to, recreate the wheel, but there's some just wonderful things that other states are doing. So that was Colorado. Shortly thereafter, I met Valerie, and Valerie's already on the road to getting that done, and then Keith was going down that path too. So we took the work that they had done and then tweaked it a little bit for Georgia. So far, let's see, it says that we, don't indemnify, defend, hold harmless, which made me feel really good when Keith was talking about that in the boot camp, that we already had that knocked out. We don't have to worry about that. Be bound to terms and conditions that are unknown at the time of signing such contracts, which may be unilaterally changed by the other party. That was the Georgia specific that I added in. Just the web links that we've all had to deal with. My biggest concern is somebody can change that information tomorrow after you've signed the contract. So that has not been tested yet, but
that was the one that we tried to include that did not make it through. Everything else made it through. That was the part that did not pass. So I'm jealous.
We're jealous.
I'm jealous.
Those are the two clauses that we need to include.
Well, it was that moment in time I was like, I'm going to go for this, because you usually get one shot at things legislatively, and then it sticks around for quite some time, which is one of my concerns also about the policies. Parts is when they legislate policy, a lot of times folks don't go back and revisit those, and you may be, for example, we have a certification with regards to Sudan that you're not a scrutinized company, but I'm not really great at international politics, and it's fairly old.
Is that a fire, Joe?
Okay, ladies and gentlemen, I just want to say that this panel's discussion is so hot that it set off the fire alarm, and you cannot plan for that, ladies. So please proceed.
All right. Let me just, do we have the slide? Oh, thank
There you go.
I've heard some rumors. I heard it out there that we pulled the fire alarm somehow or paid someone to do it to get out of our presentation. Not true. There's lots of attorneys in the room who I think would defend us, so we'll probably be all right. Okay, McCall.
As I'm saying, I'm concerned. The concern would be when statutes are legislated, policy concerns change as time goes on, and when are they going to be revisited?
Legislation doesn't.
So yes, we have one with a certification that a supplier certifies they're not a scrutinized company, and it relates to Sudan, and it's 20 years old, and it said that they were going to revisit it on an annual basis, but I'm not aware that it's been revisited. And I don't really know enough about foreign policy to advise anything. So, but the certification's still there, and the only time I've seen somebody say that they're a scrutinized company is when they accidentally check the box. It's usually, oh, that was a mistake. So that's just one of the concerns. The rest of the legislation, again, follows very similarly to what Idaho, what South Carolina, and Colorado did. And I will tell you, we're in litigation right now in Florida. And so I will let you know in another year as to how that works out, because it's a software company. We procured under a reseller agreement. One of our universities did. It had an automatic renewal provision, which is clearly supposed to be void under our law. And so right now it's in Florida and it's being interpreted with Florida law. So I'll let y'all know next year if I'm still friends with Florida.
Excellent. I mean, I think, so McCall makes a really good point, and I know the best example I can think of in Idaho is not related to one of these mandatory terms, but to your point, we have, the only preference we have in Idaho is a printing preference. It's a preference for printing that's done in the state of Idaho, which is really random, and everybody always says that. I'm not offended because I'm like, yeah, it's pretty random. I will not guess at how that became part of our statute, but it's very old. It's decades old. And I'm not sure if anyone could articulate a reason why we think that's really important. But once something is in statute, it is so hard to get it out, right? I mean, even if we look at it and say, this doesn't really make sense anymore, why is it here? The effort to get those pieces removed. So right now, Idaho sees the Chinese government as a threat, right? That's by policy they've said, now by statute they've said, we're not going to contract with a company that's owned or operated by China. Okay. But that may not always be true, but getting the statute changed will be, an act of Congress, right? Bad analogy there, or good analogy, but it's really hard. And so that, I agree. I think that's one of the challenges is maybe this is completely not relevant anymore, but it's not like we can just say, this isn't relevant anymore, so we're not going to follow it. We have to follow it.
In California, we see similar with the drug-free workplace. I was talking with one of the attorneys who's been in our office a while, and I guess the rental car companies kind of threw a little problem with the drug-free workplace, especially in California, where marijuana use is legal. And we read that clause real narrowly, which you have to have a program, and the program just needs to advise employees. And so you could read it in a way that could still make it coherent with California state law. But I know she went back and forth with rental car companies quite a bit on that, which I'm not sure that those are the employees that I want to be, looking at drug-free workplace issues, but that once you get it in, there's no really going back to change it. I think the problem that we see is, when you see these proposals come in, I think that makes us wary, right? Because anytime we're doing one of these public policy legislative initiatives, we're going to need to live with it. And so we try to provide technical assistance to this extent we're permitted through our legislative channels to, shape that. You can only have so much influence, right, in the legislature, but we do try to provide that technical assistance as to how this would be implemented by practitioners. Yeah.
Oh, okay. That's our really, really important slide. Make sure you write all of that down. So, I think we've sort of touched on a few things here. And Megan, do you have any that you want to jump to before I get into some of the questions that we had identified?
I do not currently have any questions. Please ask questions.
Okay.
Keith has a question.
Keith McCook has a question.
I know you're shocked.
I'm frightened. Please don't give him the mic.
So one of the issues that we've really struggled with in this topic area is since we added the statute and kind of followed George's lead, if a vendor submits a proposal or a bid that says expressly, in effect, we're not going to do the drug, we disagree and we're not going to do drug-free workplace, we're not going to implement the policies, right? We're going to boycott Israel. Right, or whatever the new statute is. We're not going to do the statutes that California talked about. What do you do? And the reason I'm asking the question is because in my state, I've had people argue, even one of the chief procurement officers has advocated, well, okay, the vendor submitted a proposal that said, you're going to indemnify us and Idaho law is going to govern the contract, which would make them non-responsive to a material requirement of the solicitation, and so we cannot award them a contract. And the argument has been made, well, if you're right in this theory that the law controls over the contract and the law is incorporated into the contract, kind of like the Christian doctrine, then South Carolina law controls no matter what the statute says, and therefore they're responsive. So we don't have to worry about these terms and conditions anymore. We can just ignore them. And I thought, that's a little circular, but I don't know what y'all's reaction is. So would California say, well, it's part of the law, it's in the legislation, you're okay? Or would you say, no, I don't, even though I've got an argument that it's incorporated by law, we're not going to move forward with that contract? Or same thing for you, McCall, in Georgia. If they say point blank, Mexico law applies, and are you going to rely on this and say they're responsive, or say, no, we're done? And because I don't have an answer, it's a definite issue.
I think we say non-responsive
Yeah.
prior to award, but we tend to find it by our, sister departments after award, where the contractor has not signed the contractor certification clauses, and sometimes the departments will say because they refuse to sign the contract certification clauses. I don't know if you want to speak to the enforcement over the purchasing authority.
Yeah, I mean,
The teeth that we have as a control department.
Yeah, we have the same. We don't necessarily have so for non-IT services, they sort of have a separate certification of certain clauses. Ours are just contained in the standard terms and conditions, and when you submit your bid, you're agreeing to those terms and conditions, unless we give an opportunity, and it generally only happens at our level, at our central procurement office level, for them to say, no, I would like to negotiate on any of the terms and conditions, right? But generally, our state departments don't have the authority to do that. And so, yeah, we deem it the same, that if you come back, and we have had a couple of instances where they've said, well, wait, I don't agree with the drug-free, workplace policy, and I'm not going to agree to this, and I'm not going to. It's kind of like they're giving us that extra information, because if you've submitted your bid, you've already said, because we put in there, these are all the things you're going to have to agree to. I'm sure most states do that. Here's the standard contract that you'll be agreeing to. We put all that out there in the solicitation. So they already know, and when they submit their bid, they're agreeing to all of that. And so if they go that extra step to say, wait, I disagree with that, we don't waiver. I mean, we don't negotiate on that. Like it's a law. You have to commit to it. And if you're disagreeing on that, then you're out.
But to Keith's point, so on the so when the procurement division does audits of our other contracting departments, if they see contracts where the contractor did not sign the certification clauses, they'll ding them on the audit and say, the contractor was supposed to sign on these clauses, and it can impact those departments' purchasing authority because they aren't making sure that the contractor signed the certification clause. So that's kind of like our little control department way to exert our influence over departments is, hey, if you aren't making sure they're signing those certification clauses, you could risk, losing your purchasing authority. But it's a rare situation, but I do know some contractors try that trick, and that's the way we try to rein in departments from accepting that trick.
So in Georgia, we allow red lines of contracts in our solicitation documents. So it's put out there as part of the solicitation. And I haven't received a bid protest on that provision yet. So effectively, it hasn't been an issue. What we would do is tell them in negotiations we will not accept it because it would be contrary to statute now, which is a wonderful thing to have. I'd say that's the biggest benefit of the statute is just being able to hand it to.
Which point?
Yeah, so here's 3 AG opinions and the sentence here. Yeah, so we hand it, and that's why I think the big benefit has been. Does that answer? Because otherwise, we're a state that's going to void the contract if it has a provision that's contrary to law and contrary to our. It's going to void the provision if it's contrary to that statute that we just looked at, and it's going to void the contract if we don't have, for example, they took exception to drug-free workplace.
Yeah, I think my answer is probably going to be a little bit of it depends, because even though I'm a recovering attorney, I still have that phrase in my brain at all times, lawyer's best friend. I think because of the way ours are written, I don't think that sort of circular argument would work, because what our requirement is that you have to have a written certification, and if you don't have it, the contract is void, right? So I think we would certainly find them non-responsive for not agreeing, and I think we don't negotiate a lot with most solicitation types. So they can ask a question during the Q&A, and if they wanted to raise it then, but our answer would be, no, we're not going to accept a change to that requirement because it's the law. We're required, I have to have that written certification. And if it was a contract where we were negotiating terms and conditions, same thing, we would just not agree to a change because it's required. So I don't, right, and that's sort of where, and this gets into a separate question, but sort of the enforcement, are we actually going to enforce it if we have that written certification, but we have some reason to believe that the contractor is not complying with it? And I think that's going to depend on what the nature of that situation is. I think the ownership by the Chinese government, we're much more likely to actually say we're going to terminate the contract because it's a security risk, as opposed to a policy concern. So, I think that's kind of where we are, but we certainly, I get the question, Keith, and I think it's a good question. If you're required to follow the law and it's sort of read in terms of the way the Christian doctrine works, that it's sort of read into the contract anyway, then yeah, does it really matter? Right? Are they really non-responsive if it's going to be read into the contract anyway? But that's not the way it works in Idaho, for sure.
One follow-up question, and the reason I kind of posed the first question was to contrast it with this question, which is, okay, so many of the contracts that are really problematic are the ones we have a hard time negotiating. Either it's licensing agreements where the amount of money involved is not enough to actually get the vendor to the table to negotiate, but it's still a contract, and whether they're getting that money directly or through a reseller, it's still a contract, and I can't argue that these requirements aren't there, but the vendors won't even call you back. Right, and we talked about that this morning. And then the other one is, we had one within the last 2 years involved Microsoft Cloud Services, and I can't remember the name of the contract, but I've been negotiating with Microsoft for 25 years to get their contracts to comply with state law. When we called them on this one, the Microsoft lawyer got on the phone and said, we're not changing a period. We don't care what your state law requires. You can get our cloud services on our contract the way it's written, or take a hike, which was a real shocker. And so now I've got a must-have contract, right? And the vendor has the market power, and they will not talk to me and will not change a period. Well, now, if I'm going to throw people out as non-responsive because they won't change their contract terms, can I then turn around and say, yeah, but the contract with Microsoft on these licensees is not illegal or void because I'm going to rely on the Christian doctrine and the corporation? And it's almost like I want to use it both ways at the same time, and that's not a very comfortable place to be as a lawyer, right, or to advise the client, but it's completely untested. I don't know anybody, any authority, and so if anybody in the room's got an idea or a solution of the panel, that's the challenge right now. I think what Georgia did in Idaho and Colorado, now South Carolina, is a step in the right direction, but it opens another can of worms.
So I'll tell you one thing we have done in California, and one of them is a very large vendor that starts with an O. And so what we decided to do, because we're pretty baked in with a lot of the services that we use that are theirs, and so we're still not done. It's been over a year now, but one of the things we did was bring them in and say, okay, let's talk about what your issues are. Let's stop doing this at a State Department level that they may or may not have the authority to do, plus my leverage procurement agreements at a statewide level that I battle with you every year on, plus our financial system. Like, let's stop doing this. And we brought them into the room to say, okay, let's have a discussion about your pain points, our pain points, and can we come to a consensus on some model terms just for you, for all state contracts that you can live with and we can live with. And so no departments ever have to negotiate again. That would be, in La La Land, that's what I would love to happen. But and we've talked about your click-through, that's 1,000 pages that you might change one single word in every year. And so we've gone down that challenging path of negotiating with them directly and getting agreement, and we're very, very close, that you are going to agree to this set of terms. We're not talking about indemnification anymore. Like, we're not having that conversation. Stop bullying everybody about indemnification. And then some of the other, points, your click through on your website versus you have to have the hard copy 1,000 pages in the contract. yes, we will look at it and we will see what conflicts, but we're not going to allow you to have this electronic business anymore. So we're able to bring them to the table, and we've done it with a couple of other large software vendors as well, recognizing that our state uses a lot of that service and it's a waste of resources. And I'm concerned about uniformity when it comes to information technology contracts, that I have 150 state departments and might have individual contracts that have who knows what kind of terms and conditions, because although I'm supposed to see all of them, I have no idea that I actually see all of them. So that's kind of where we're at as a solution, is to try and work with them directly to get to some consensus.
We've talked about doing something similar and decided that we were going to let California do it first. Then we can say to them, but you agreed to that with California, because let's be real, I'm not getting it on my own.
Mm-hmm. Well, New York is actually who started it. They have a handy agreement, and our first position was, we want what New York did. And they said, no. And we said, we want what New York did. No. And we've gone back and forth on this, but I think we're in a better place than we were, but we started with New York and we said, you did it for New York, why can't you do it for California?
Exactly.
So
I think there was a question, Megan, behind you. Okay.
A comment and a question. Keith, to your question about the certifications and companies that refuse to give them, I think we approached it slightly differently in that most of our rules like this are executive order rather than statutes, and they actually put the onus on the state employee and say no state employee may enter into a contract with a company that does not provide a certification that X, Y, and Z. They usually also say that a failure to update a certification, if a certification becomes out of date and inaccurate, or submitting a false certification is grounds for suspension and debarment of the vendor. The issue that I wanted to pose to you guys was, okay, so we usually also say an employee or an agency may rely upon a certification provided by the vendor. But what do you do when the certification is obviously false? And for example, we had one earlier this year. I got a call from procurement, and the officer said, I think we have a problem here. Sent over the certification on the what we call the evil foreign governments clause, the no China, et cetera. And the certification was signed by a company that appeared to have a Chinese name. The corporate seal had Chinese characters on it, and when I started looking into the company, it held a patent from the U.S. Trademark and Patent Office in which they identified, and the application for it identified themselves as a Chinese corporation. But
So they're saying the quiet part out loud, okay.
yeah, but the agency had already purchased the materials. So we voided the contract, but the issue is, what do you guys do to try and ride herd on the agencies who are clearly not looking into the certifications?
Enforcement's a tough one.
Yes, air dirty laundry.
I think enforcement's a tough one. I
Yeah.
think it's a matter of investigating and avoiding. I don't know that you have much other remedies other than my little control department. We could take away your purchasing authority, right? Which means, department, you did bad. You accepted something you shouldn't. Now you don't get to purchase up to, whatever, it's $250 or $1 million, whatever.
Yeah.
Other than that, I'm not aware of any other real ways. And I
Yeah.
think enforcement is a big issue across all these types of clauses, because the legislature likes to enact these clauses, but they don't necessarily give states resources to actually audit, investigate, and enforce. And so you rely on this sort of random patchwork quilt of whether somebody raises their hand and says, I think you have a problem here.
Yeah, we largely operate off of complaints, and then you have to go in but we have so many legal, statutory requirements. Child support compliance is one of them. There's probably no state department that is validating that somebody is actually paying child support in compliance with the law, right? Like we have, agencies that are responsible for that. So why would you put it in procurement and have a contract administrator or a procurement official check something like that, right? So it just seems sort of mismatched to the authorities within the state and who's responsible for what. So, I mean, we have so many that domestic partners, just things like that departments are not likely. It's in your standard language, so you're agreeing that you will comply. But whether you're actually complying with it, it's not likely happening unless you get a complaint.
Maybe it goes to Valerie's point, which is a sort of sub point, which is when the legislature enacts these requirements, they do each one differently. Yeah. Some you have to sign under penalty of perjury. Some you have to submit before a bid. Some you have to sign once the contract is awarded. Some only apply to contracts over 100,000. No one could keep track of this. Like, I need 18 pages of charts to figure out when it applies or when it doesn't and when you're required. I do think one thing, if I had my little fairy godmother wand, would be to try to get consistency. If you're going to legislate, this is the way we want you to do it. And I like the penalty of perjury, because if you sign penalty of perjury, I do think you could probably try to bring, you could go to your DA, right? You could try your AG's office and see if they bring some sort of false claims or other action. I don't know what they would say to that, but penalty of perjury seems to give you a little more of a stick.
So for ours, to go back to that point, that legislature oftentimes won't go back and revisit things. For E-Verify, they're required to submit an affidavit with the information, your E-Verify number, things, basically all the information that's required to be submitted is information we cannot audit because the federal government would not give us access to that information. And then the board that's supposed to be overseeing this non-compliance aspect, because it touches on a number of different areas in law, is now defunct. So we have a requirement to collect these affidavits, which can make a bid non-responsive in theory, but we've kind of pushed the border on that. But local governments very well may be throwing out bids that could be the best value, lowest cost, and the enforcement aspect it's just a little bit, well, in theory, if somebody comes to the procurement community and said, how should we do this? We'd say, there's a debarred and suspended thing that we already do, and we just check the E-Verify list, and there you go. Are they using, are they registered? But we usually find out after the fact, and then nobody wants to touch a hot button thing like, immigration compliance. So they're not going to go back necessarily and address those things right now.
Well, and I think one of the things I've seen, a lot of the things that make a contract void, like what Georgia has and what we have in rule, usually sort of from a procurement perspective make sense, right? They're things that we have to fight about all the time, so it's trying to make it more efficient for us, easier for us to negotiate, because I can say, look, if this is in there, it's going to be void anyway, so let's just find a way to make this work. But some of these other ones where we have to have the written certification, I think a lot of times they don't do what the legislature actually wants them to do necessarily. So on our piece of code about not boycotting Israel, we had someone come to us and write a formal letter basically saying, we think you're not complying with this, because we had a contract with a contractor who had signed, we had that written certification, no evidence that the contractor was boycotting Israel, but they sold products made by a company that may or may not have been boycotting Israel, right? But that distinction totally makes sense to me as a procurement person, doesn't necessarily make sense, and that's no offense to the legislature, but they're not doing the work every day, right? So they're seeing us buy products that they feel like are not meeting sort of what the policy goal was, but because of the way it was written, we're totally in compliance with it, right? And I think our China requirement is very similar, right? I don't contract hardly ever with, I don't think I've ever contracted with a company that's owned or operated by the government of China, but do I buy technology that was manufactured and or assembled in China? Heck yeah, all the time. I think that, so a lot of times these end up in there with a specific idea, but the way that we have to build it into our contracts, doesn't quite fit.
think that goes to the question of how this began, like why are we doing this? And so, is this a reaction to something, which it often is. And one of the examples in California was there's a mandatory contract clauses regarding consulting service contracts, because there was sort of a rampant abuse in consulting contracts. So we require the resumes of all the key personnel as an exhibit to the contract. We put in detailed scope of work. We put in, you have to give us our hourly rate and you have to have price per deliverable. So there's all these requirements for this one subset of service contracts. Why? Because the legislature was sort of tired of these abusive practices regarding consulting contracts. But on the flip side of that, you could say we've gone too far. I mean, now we could have created barriers to entry for small businesses. The resume requirement can be challenging for contractors. Maybe it's been overdone because it was a reaction to something. So to your point about it doesn't always do what they want it to, sometimes it goes far beyond what we're really trying to remedy or address.
Yeah, absolutely. All right, well, for some reason, our hour seemed to go really fast. I don't know why that is. It almost feels like we lost a few minutes in there.